The majority of people will never discover this until the moment has already passed them by. Not because the information is locked away somewhere, not because it is beyond comprehension, but because the type of changes that silently reshape millions of lives seldom trend on the internet or land on front pages. They happen inside courtrooms, communicated through legal language that ordinary people almost never take the time to read. And by the moment the typical American realizes something has fundamentally changed, the monetary consequences are already underway. That is exactly what just took place. The Supreme Court of the United States has issued a unanimous 9-0 ruling. Every single justice from the furthest right to the furthest left reached the identical conclusion. And what they decided has permanently transformed how retirement operates throughout the entire country. Not temporarily, not within a single state, not for a particular demographic, but permanently and across every jurisdiction. If you hold a pension, invest in a 401k, collect Social Security, or have ever built financial plans assuming that retirement regulations would still be intact when you required them, this decision has a direct impact on you. The reason this is so critical right now before the media fully catches up is that the safeguard it establishes does not automatically attach itself to your circumstances. You must comprehend it first. A Supreme Court ruling is only valuable to those who recognize how to apply it. So let us examine what actually transpired. Why 9 justices who almost never see eye to eye reached unanimous agreement here, and why legal scholars are already calling this one of the most consequential retirement decisions in the last 50 years. Before we proceed, you need to grasp what was genuinely on the line because this case did not originate as a landmark moment. It began with a single person refusing to accept that the government could rewrite the terms after the game had already been underway. Picture committing 30 years of your existence based on specific assurances. Not informal assurances, but legally binding ones. Assurances codified into policy woven into the retirement framework you funded with every single paycheck year after year. You shaped life choices around those guarantees. You selected a career in government service because the pension calculation justified the decision. You remained in a state you might have otherwise departed because its retirement tax framework supported your long-term financial well-being. You structured your savings, your retirement timeline, your investment portfolio, all constructed upon a system the government itself engineered and invited you to rely on. Then one morning, without consulting you, without securing your consent, and without acknowledging the decades of preparation you had already undertaken, the government altered the terms. Not merely for future enrollees, but retroactively for individuals already deeply committed to the framework. People who realistically had zero opportunity to begin again. That is what occurred to the retiree at the heart of this litigation. And that is what the Supreme Court was tasked with evaluating. The inquiry was not whether governments can revise statutes. They absolutely can. It was not whether retirement frameworks can undergo reform. They certainly can. The actual inquiry was far more specific and significantly more consequential. Can a government modify retirement regulations in a manner that directly damages individuals who organize their complete financial existence around the prior framework? The unanimous response from all 9 justices was no, not unless the government satisfies an extraordinarily elevated constitutional threshold. Not unless it can demonstrate the modification is sufficiently warranted to supersede decades of genuine life planning constructed upon the original statute. To appreciate why this carries such enormous weight, you need to understand the central legal doctrine at the core of the litigation. The justices concentrated on a concept recognized as reliance. It is a legal term, but the underlying idea is straightforward. When you make significant life choices grounded in an existing regulation, when you pour years and capital into a framework because of how it functions, you are depending on that framework. And when the government constructs a framework expressly intended to influence long-term conduct, promoting saving and planning many decades into the future, it cannot subsequently dismantle that foundation without being held responsible. That is what reliance signifies. And what the Supreme Court has now affirmed unanimously is that retirement planning represents one of the most compelling instances of reliance within American jurisprudence. Retirement is not a short-term selection. It is not something individuals conveniently recalibrate every couple of years. It is a lifetime dedication built upon the assumption that regulations will stay sufficiently consistent for the strategy to work. Prior to this ruling, states possessed wide latitude to alter retirement-related statutes. They could revise pension calculations, impose fresh taxes on retirement earnings, or increase the threshold for full eligibility. They frequently defended these measures by contending that governments require adaptability to oversee budgets and react to economic circumstances. On its face, that reasoning appears sound, but it disregarded something fundamental: the actual human beings affected by those modifications. The educator who invested decades in a classroom because the pension rendered a modest salary acceptable. The firefighter who remained in a physically grueling profession because retirement compensation made it financially viable. The retiree who uprooted across the nation for favorable tax treatment only to witness those advantages vanish shortly afterward. These are not theoretical examples, these are actual lives. What the Supreme Court has now established is that those choices, those years of preparation, and that dependence on government-established frameworks deserve constitutional shelter. This is the point where the ruling becomes genuinely revolutionary. The court did not merely state that reliance has significance. It formulated a three-part constitutional examination that states must now fulfill before modifying retirement statutes in ways that disadvantage individuals who depended on them. More critically, the court transferred the burden of proof. Previously, retirees bore the obligation to demonstrate that a policy modification was unjust, frequently demanding legal resources they simply lacked. The state held the upper hand. Now, the dynamic is inverted. The presumption begins in favor of the person. The state must establish that its modifications are warranted despite the dependent citizens placed on the original regulations. This reversal is not insignificant. In legal proceedings, whichever party shoulders the burden of proof frequently dictates the result. By assigning that obligation to the government, the court has fundamentally reshaped the equilibrium of authority. For the first occasion, retirement choices made by millions of Americans are being acknowledged as constitutionally shielded reliance. Nevertheless, it is essential to remain grounded. This ruling does not permanently lock retirement statutes in place. States retain the ability to enact modifications. What has shifted is the benchmark they must achieve. The threshold is now substantially elevated. This is not an absolute guarantee. It is a protective mechanism. And like every protective mechanism, it only serves those who comprehend it. In the following section, we concentrate on who gains the most. Public sector workers are the initial group directly affected. Educators, law enforcement officers, firefighters, healthcare professionals, and government employees nationwide. These people frequently accepted reduced compensation in return for dependable retirement provisions. When those provisions were subsequently diminished, it produced severe ramifications. This ruling now provides them with firmer legal footing to contest such alterations. The second category encompasses retirees who relocated based on state taxation policies. Numerous individuals moved during retirement to minimize taxes on earnings like pensions or Social Security. When states subsequently revise those policies, it can substantially affect their financial situation. Under this decision, such choices may now be classified as protected reliance. The third category is employed Americans still accumulating retirement savings. Those depositing into 401ks or IRAs based on present regulations are likewise safeguarded. Retirement preparation is a continuous endeavor, and every contribution constitutes reliance on the framework operating at that moment. The three-part examination governs how the safeguard functions. First, did you make monetary decisions founded on existing regulations? Second, would the modification inflict genuine damage? Third, can the government defend that damage with a sufficiently compelling rationale? Only when every condition is satisfied can alterations proceed. So, what action should you take immediately? Begin recording everything. Preserve documentation of tax policies, pension specifics, and account records. These could become essential evidence. Consult with a financial professional who comprehends these developments. Examine your retirement strategies thoroughly. For public sector workers, compare your pension provisions against any recent modifications. This ruling illuminates a more profound reality. Retirement security has perpetually rested on trust, confidence that frameworks will stay dependable. For years, that confidence had no genuine enforcement mechanism. This decision alters that reality. It proclaims that reliance is not simply a hope, but a constitutional concern. The narrative is just getting started. States will react in varying fashions. Fresh legal confrontations will establish the boundaries of this ruling, but one reality is unmistakable. The period of silently modifying retirement regulations without repercussion has concluded. What you choose to do now carries weight. Those who comprehend and respond to this will be better positioned. Understanding here is not merely influence, it is defense. Pass this along to anyone preparing for retirement because financial circumstances do not pause for awareness. The Supreme Court has declared its position unanimously. The communication is unambiguous. Retirement regulations can no longer be modified without responsibility. This is a long overdue transformation, and it belongs to every American who prepared, saved, and placed their faith in the system to